This is a Shoesmiths podcast.
Hello, listeners, and welcome to the first ever episode of COPcast with the Shoesmiths Quarter Protection team. You are currently listening to Lauren Miner, an associate in the COP team, and then my two co-hosts will introduce themselves now, if you will.
I'm Lucy Taylor. I'm a principal associate in the Quarter Protection team, and I work with Lauren.
And I'm Rebecca Bristow. I'm a senior associate in the Quarter Protection team, and I work with both of them.
Hey,
welcome.
Yeah. So I guess for anybody tuning into this, to kind of set the scene, shall we, and give an idea as to how we kind of came to doing this. So this is not legal advice. So just to be really clear from the outset, this is the ramblings, if you like, of three COP lawyers who we are desperately missing kitchen chats and coffee chats. And so we thought, we thought we would just kind of come together on a very grey afternoon and just kind of chat through some things that have cropped up. Is that right, ladies?
Yeah, and I think, to be fair, there's been quite a lot, hasn't there, in the media and in the news at the moment about thoughts, wishes and feelings in quarter protection cases and with individuals who've lost capacity. And we thought it would be a good chance to have a chat about what that means and how that comes up on a daily basis, perhaps. Is that fair to say, with our clients?
Yeah, I think that's absolutely right. And I think at the moment I've seen it all over LinkedIn and all over social media generally about the whole Britney conservatorship, and that's absolutely kind of brought it home. And just some other things that have been happening in, I mean, it's LGBT History Month, and a couple of things cropped up there. So yeah, we thought we'd kick it off with thoughts, wishes and feelings.
So usually when we're in the office, I think it's fair to say we're quite a sociable team, and we like to talk about things both work life and personal life. But I guess with the nature of quarter protection clients is that we often find ourselves getting very involved in elements of their life that you wouldn't usually find in other areas of the legal profession, I guess. So we tend to have to bounce ideas around and talk about individuals, what their wishes and feelings are, and how we best put that into our day-to-day practice as lawyers, I guess.
It can be really difficult though, can't it? Because with some clients that come to us, we don't know anything about them. You know, when we get referrals via the panel, or you know, we get asked to maybe get involved with a local authority case or something like that, we often don't know anything about them. And then it's kind of backtracking and trying to build up a picture. But I do always worry that, you know, we will miss something that's fundamental. So I mean, some people tuning in might kind of know what a lasting power of attorney is, but they're absolutely key to giving people the kind of greatest say and choice in terms of, if you're in a situation where you don't have mental capacity, making sure that whoever your attorney is, making sure that they are going to voice for you and voice your thoughts, your wishes, your feelings, not your attorneys, not, you know, a panel deputy that you might end up with, but choosing an attorney who knows you and knows what you would want when you can't advocate for yourself. So
it's so important, isn't it? Because we so often see it go wrong, especially through our panel cases, where a person hasn't perhaps taken those steps to make their thoughts, wishes and feelings known, hasn't said, right, if I lose capacity, I want my brother or my sister or my partner to make those decisions for me. And then you're faced with somebody who doesn't know you at all, making an application to a court who doesn't know you at all. And your autonomy is completely lost at that stage, because it's so hard to unpick what you would have wanted.
Well, this is exactly what's happened to Britney, isn't it? You know,
I was going to say that's a good segue.
It's absolutely what's happened. Although, from what I've seen of the documentary that's been put out, she did attempt to say, I don't want my dad involved in managing my affairs. And I don't know the correct use and terminology, and I'm not an American lawyer and have no idea, but it was very clear from one of the lawyers who was talking in the programme that she didn't want her father involved. And actually a lot of the time we don't want, I mean, I don't want my parents involved managing my affairs if anything happens to me.
So I haven't seen the documentary. So how did he get put in a position? It's a conservator. Is that the terminology they use in the States?
I think I noted a key difference between the way it works in the US and the way it works in the UK. So we work for a professional deputy essentially and manage people's affairs, and in our team we exclusively deal with property and finance, but in the US it's called a conservatorship, and they, similarly to in the UK, have two branches. They have the property and finance, which they call I can't remember the term now, but then they also have a health and care arm, which they call conservator over the person, and it seems like they're far more liberal with that arm than we are here in the UK. So in the UK, we're very much health and care decisions are very much left down to P or the person in question as much as possible, and ideally they would only give authority for a third party to make that decision if it's absolutely necessary, and limited to only very much that sole decision if possible. Whereas in the US and in Brittany's circumstance, her dad made the application to the court, so the potential deputy or attorney, or in this case conservator, applied directly and said, I want to be both finances and health and care, essentially. And I don't know, obviously it was a documentary designed for the average layperson, so they didn't go into the detail of the application itself, but I think it would be interesting to find out more about. And I did do a bit of digging, but didn't really find anything.
That's not surprising though, given the tone of what's happened.
What I found so fascinating is that how many lawyers agreed to be on that documentary and were just speaking really openly. I was just thinking, I don't think there's any way I would ever go on a public documentary and talk about any of our clients, but the court didn't really seem to dig down to any great length, judging by the time it took for the application to be issued. I think he applied and then he was made temporary conservator in a matter of days, and then only a few months later permanently. So how much did they dig into his capabilities? How much did they dig into whether it was necessary for him to be both financial and health? So
is it a much more blanket approach then in the States than it is here?
I don't know. I mean, I think Lauren's right. I think there's so much that we don't know. You know, it was produced for TV and it was produced for maximum effect. But what came through was that there was certainly a consideration as to whether or not Brittany had got capacity to be involved in the proceedings, so to litigate, almost, did she have litigation capacity? And there was a lawyer who was saying, I was representing her, and he wasn't even provided with a copy of the medical evidence or the report that said that she didn't have litigation capacity to be able to be involved in the proceedings, which I think, put it in the context of here. Can you imagine if we were in court of protection proceedings and we weren't given a copy of the medical evidence regarding our client's capacity? So the whole process seems very secretive, and it's ironic, really, because the court of protection in this country, in England and Wales, has been deemed to be the secret court, and then you hear what's going on in the US, and it's like, crikey, this is really quite frightening. And I think that's the angle that the programme was coming at, that it's that very secretive, and so all of a sudden her father's her interim conservator, and then he's her full conservator within a very short period of time, in which I think she had consented to the appointment, but there was some suggestion that she'd done that because there'd been a bit of bargaining in terms of her having access to her children. So it was really eye-opening. But I think the key thing was that this lawyer who had purportedly tried to represent her disagreed with the judge's decision on whether or not she had capacity to be involved, and yet that didn't seem to go anywhere. And he was saying that she really didn't want her father involved. She didn't want her father. And there was at various points and referred to as a lawyer or another independent body who seemed to be appointed jointly with the father, but there was very much a focus on it being almost like a business.
Yes, very much so.
Business rather than actually somebody needing to have somebody to support them. And in fact, there was no the whole situation, it seemed very much a case of taking away her autonomy altogether, not
completely
as we
agree.
would find whereby, you know, a deputy is there to support the individual to make the decision for themselves and only make a decision where the individual can't. It's the total opposite. And it really, you're sitting there watching it, well, I certainly was, and thinking, okay, I can see why people are, you know, jumping on the Free Britney hashtag wagon, because it just feels that she's got no voice. It feels that she can't speak up. And I think later on, as the programme progresses, there was something said, and she was recording some video documentary, and she said about the conservatorship that they hear me, but they're not listening. And yeah, it's quite powerful.
I did find that very notable throughout the documentary. I thought what was really interesting is that Britney, one way or another, whether anyone believed she had capacity or not, there were plenty of occasions where she was saying things or expressing opinions. And like that attorney that you mentioned, that she tried to instruct to represent her own feelings. I think the court eventually said, we don't believe she has got capacity to instruct her own attorney. So they just appointed a third party to represent her. And it didn't seem that there was any conversation between Britney and her then appointed attorney. So how is that party then able to understand her, what she wants and what she feels and how she wants to progress things, when actually the attorney who she first instructed was saying, you know, I undertook a full capacity assessment to check that she was able to give me instructions. And it was, he seemed like the party involved in the documentary that most seemed to be listening to her throughout. And I think what it made me think was that in the UK court of protection, P is very much at the centre of absolutely everything. Everything we do is, what would P want to do? What is in P's best interest? If P can't express their own feelings, let's talk to the people around P, try and understand what they would have wanted. The court is meant to represent P and advocate for them. You know, all the parties, even when they're in disagreement, we're still meant to be focusing on P. But in the US, it sort of seemed like she was swept under the carpet a little bit. And like you say, Lucy, it was very much a business arrangement where, you know, this was it was an organisation, it was structured. And I don't know whether that was because Britney is such a massive figure, you know, she earns tens of millions of dollars a year, and she is a business essentially, isn't she? I don't know whether that had something to do with it.
Do you think it's to do with her role in the media's influence had a big impact on what happened and the way it's been managed, or is that just a blanket approach? I suppose again in the US, is it less focused on P?
I would probably suggest it was the latter. I think certainly in terms of the evidence to support her, maybe her mental health struggles, or you know, when she started to deteriorate, that was very well documented. And I can remember actually when she shaved her head, and it was quite shocking at the time. So I certainly think that the media attention that was around at that time supported the evidence that she was vulnerable. No doubt she was, you know, anybody in that situation would be. I think as it went on though, it was more of a lack of focus on P. P does not seem to be at the centre of it at all. And what I've also found really interesting about it is that we often work with high functioning individuals who don't have capacity. There does seem to be this suggestion from the Free Britney movement that, oh, well, she's high functioning. So you've got two real ends of the scale here. I could absolutely see why people were getting, you know, really upset about it and really wanting to kind of fight for her and to get her feeling liberated and back in control of her own affairs. on the flip side of it, I could also see how there is a misunderstanding that somebody who is high functioning doesn't necessarily always have mental capacity to make the decisions that they need to. So it's really interesting. I definitely recommend you watch it, Becca.
Yeah, me too. It's really interesting. And I thought it was a bit black and white, actually, in that it sort of the people that were watching everything unfold, it seemed a bit sort of like it's either you need a full conservatorship and that person needs absolute control and P is not able to express anything, or they don't need anything at all and they can completely manage their own affairs.
So
whereas this is very much, and many of our clients are, there was very much a forgetting that, if Brittany can say, or actually I really care about this, or actually I'd really like to do this, even if she can't manage tens of millions of thousands of dollars, she can still make certain decisions, and those things should be respected. What I thought was particularly interesting in terms of how we manage clients like that is that in the COP in the UK, I think where there's any concern as to whether there's conflict or whether parties won't work well together, I would have thought that a third party would be appointed, and that's where we use things like panel deputies, isn't it?
Absolutely. I mean, you just have to look at it, and in our jurisdiction, if you've got P saying I absolutely don't want this, that's exactly what the court do, and there's case law to that effect. That has happened. The court has decided to not appoint a mother in one particular case because of P's wishes and feelings, that they valued that individual valued that relationship with her mother, that she didn't want it jeopardized by suddenly her mother becoming her banker, for a better word. I mean, that's a phrase that in our world we bound around, don't we? Be the relative, be the husband, be the wife, be the parent, not the purse string holder. And it was absolutely that, and that's where we come at it from. So I agree. I was really surprised, and there did seem to be a suggestion of some independent, or at least a third party lawyer, but I was surprised to see her father featured at all, and I don't think the same decision would have been made in our court of protection.
And actually, especially given the value of Brittany's estate, I mean, they set the background a bit at the start of the documentary, and she grew up in a small town in the southern US, and both mum and dad got no experience. They grew up poor; they couldn't afford to go to New York to bring her to auditions or whatever. So all of a sudden, 20 years down the line, she's worth $60 million, and yet dad, your average layperson with no history of managing that amount of money, is an apt person to manage that. I don't think that would happen in the UK either, even if she did feel comfortable with her dad managing her affairs. I just think, and there are so many facets of her estate. She's entering into contracts, she's releasing products, she's signing up for residencies in Las Vegas, and also what's interesting is sort of to touch on the slightly more taboo subjects that we perhaps sometimes cover. Like you're saying, Lucy, do you really want a parent to be your banker? But there's also the fact that dad is essentially the health and care attorney as well. Brittany is, without putting it lightly, she's an international sex symbol, quite frankly. And do you want your dad to also be managing that, and how you come across to the media? Is that the best person to be doing that?
Yeah, absolutely. I mean, we always think, the starting point is to have somebody who knows you best, but there are just circumstances where, it's just not the right thing to do, and the financial side of it, you're absolutely right. An estate of that value, anybody is going to need support. So
conversation we have with our clients quite regularly, isn't it? If you think of the compensation claims that quite often we're dealing with, especially unfortunately for children, where that money's got to be managed for the rest of their lives. Do those parents want to go from being mum and dad, who are also having to deal with being carers on top of being mum and dad, then also being the purse strings, the banker,
exactly,
and dealing with the conversations which will have to come as they grow up through their lives? I think when I talk to my families and clients and their families, that's always the conversations that we're having. It's thinking about the future in terms of, do you want to put yourself in this role? Because not only do you have a child who's got an injury, you've also got a child who's going to go through puberty and teenage years with dealing with a brain injury on top of that. Pick your battle sometimes. It is the feedback that I often get, and us coming in and being that independent deputy, often I find families say, actually that's brilliant, because we can sometimes push those hard conversations on you. You can be the bad person. We remove ourselves from that conversation, that role.
Exactly.
Yeah. I get that quite a lot, definitely. So yeah, it's interesting times we're living in. Capacity seems to be around a lot, doesn't it?
Topic.
Yeah, definitely. The other thing that sort of made me think about it as well, and come back to that LPA point, was what happens when you don't have a power of attorney in place and you end up with somebody making the application to be your deputy that you don't want. Is one thing, that's the kind of situation that Brittany's in, but also what happens to other people who might not necessarily even find out about it all until it's too late. So I had a case a few years ago where I was instructed by a child of a gentleman to apply on her behalf, and she wanted to become his deputy. And just trying to get to know a little bit about the gentleman, and where he was living, what had happened to him, how he'd come to be in a situation where he'd lost capacity, who was in his life. It soon became apparent to me that this gentleman might have been in a same-sex relationship and his daughter might not have known about it. And actually that did transpire to be the case, and that's really tricky because the gentleman's identified as being a friend, and so we were fortunate that we'd identified him and could serve him with notice. And it actually came to light that they had this gentleman and P had been in a relationship for a number of years, and this gentleman felt that he was the most appropriate person to become the deputy and not the daughter. And managing that is a really tricky situation because the daughter has just found out about her father's private life and had no idea about it, and she had been involved with her father. It wasn't as though she just sort of reappeared on the scene or anything like that, but this gentleman had led a very private life. But I'm sure that individual would have wanted his lifelong sort of 20 years last partner to become his deputy and manage his affairs and help to make decisions about, where he was going to live, him coming out of hospital, returning home, how that was going to be supported, because he'd been there. And actually we were able to resolve it to that effect. The daughter was very understanding, but I do often wonder what would have happened if the daughter had have gone the other way and dug in, and we could have ended up in a situation there where the court decided that neither of them was appropriate if they couldn't work together, because that's always a tricky one, isn't it? Where you just can't get people to work together. But I do wonder, and yeah, I've not had a situation where that's happened, but it's absolutely something that is perfectly feasible. It's why I think really... Sorry, go on, Becca.
No, I was just thinking that sort of brings to another point to the conversation, in that this point about notice, it's interesting, isn't it, that the Court of Protection has sort of had a real push on notification in applications in the last couple of years. So whereas once upon a time there was a requirement to notify parties, and perhaps if you put one or two notifiable parties down, that would often be accepted. Now it's very much party line. You must put 3 parties down at least to be notified of this application. But on the flip side, we've got LPAs where we're no longer notifying parties intentionally, and I think it's a really weird way of coming at it, that the court are pushing for in the formal process notification, whereas the slightly more informal process where individuals can actually do that on the internet themselves without a practitioner helping them, that's not being policed quite so strongly anymore.
I mean, when I was dealing with lasting powers of attorney, and I'm going back years now, but I always used to suggest to the donor when they were making their powers of attorney that they do include a person to be informed when the power's registered, because it gives an extra set of watching eyes, doesn't it? You always want to think that whoever people are selecting as their attorneys are trustworthy and are going to make, you know, decisions in P's best interests and in line with what their wishes would be. But you never know, and it can't do any harm to sort of have a watching kind of eye over things, to just sort of raise a flag with the Office of the Public Guardian if things don't quite seem as they ought to. But yeah, you're absolutely right. It's almost two opposite ends of the scale. It's almost all autonomy or absolutely kind of not.
I guess there's an assumption that if somebody's making an LPA, they're not under that. You would assume that they're not under any undue influence and they're completely doing it of their own mind. And of course, that would be the ideal scenario. Otherwise, hopefully, you wouldn't be drafting it in the first place. But
there's also what certificate providers there to do in some ways as well, isn't it?
Yeah.
But I think, you know, what we have known, and gosh, we've seen it, haven't we, for what it is. We have seen LPAs when they've gone bad. You know, we've seen it where attorneys haven't quite got it right, or actually have really, really got it wrong. And so I don't think, you know, anybody who makes an LPA or an EPA, going back that far, ever would appoint somebody who they didn't think was entirely trustworthy. But unfortunately, circumstances change and people change, and so, you know, it can be some years until that power starts to get used, and the attorney, you know, just might not be the same person. And sometimes it's also a case of, you know, they might just get it a little bit wrong and need some support, but it's helpful to have someone who is watching. I think so anyway. That's my view.
I was only a few years ago drafting LPAs as a trainee, and I did used to put I used to really try and ask people to think about worst case scenario sometimes, because I would say, you know, you're not going to be using these things now. You can if you want to, but probably not. They're more of a sort of insurance policy for the future, I guess. But, you know, especially where people had more than 2 children, if they had 3 or if they had 4 children, I'd sort of talk me through the relationships between your children. Is there any friction? Are there people who don't get along? And sometimes people would say, oh, well, the youngest is a bit of a wild card, you know, she doesn't really like her older sister, or stuff like that. And I just try and say to them, I know you'd like to think that children will all agree with each other and be focusing on your best interests, but families are complex, and you know, in heightened situations of stress, if somebody's ill, or, you know, if other things are going on, if there's financial hardship or complexity, all of a sudden those multiple different factors can sort of boil up this broth of tension, and before you know it, all manner of things are happening. And actually, that's how one of my clients came to me a year or so ago. There were 3 siblings who, at the time of drafting an LPA, all got along absolutely fine, and mum didn't think there was going to be any problem and had always treated all siblings equally. But then before you know it, when the LPAs came to be registered at a later date, one of siblings objected, and just sort of blew up from there, really. And it all got very personal and very sharp, and they ended up appointing an independent party, because it didn't, you know, after probably about a year of proceedings, just really wasn't going anywhere. So that was the best thing in P's interest, to be honest.
I've seen the other end of that. I suppose one of my more complicated files that I worked on for a number of years was where we were actually appointed as the independent body. We'd had, unfortunately, a falling out between siblings who just could not resolve their issues. And despite actually the appointment of an independent deputy, we spent several years then liaising between the parties. We could never, unfortunately, come to the stage where everybody could work in a joined up approach. And it's a shame, isn't it? Because we're all working towards P. Again, it's putting P at the middle of it, and it's taking into account everybody's opinions. I think that's one of the hardest roles, actually, as a deputy, is factoring in the thoughts, wishes and feelings of the family members who purport to know P best, and trying to sift out what actually is, where's P, where does P sit in all of this. You also have the financial aspect of that to think of. You don't want to waste too much money going around and around in circles, getting everybody's opinion, and then actually wasting time and money on getting something done for P.
And sometimes you don't get anywhere with it anyway, do you? It's it's a bit of a trial and error, isn't it? I wonder whether it's worth thinking about things that people could do in advance to try and mitigate things like this happening.
Yeah, this is really interesting, because I heard somebody mention this just yesterday, and they were saying about doing letters of wishes to go alongside lasting powers of attorney. And I haven't worked in that field for years, as I said, but that's something I'd not come across previously, and I actually think it's a great idea.
I agree.
I mean, I know that the form allows you to kind of put some guidance in there, and we were always very cautious in terms of saying, what to include, because you want to make sure you get it in the right box, basically, and don't sort of restrict the powers that you're giving to your attorneys unnecessarily. You don't want to cause any conflict there, and sometimes people didn't always put things in the guidance box, and that could cause problems. So I think if you take it offline and away from the form, away from the actual power, and you put it in a letter of wishes, and also the flexibility that gives, because you change, your wishes will change.
Absolutely.
It's a brilliant idea.
Yeah, completely.
Has anyone seen one?
I'd not done letters of wishes with lasting powers of attorney, but I did used to do them quite a lot with wills, because where they were things that were sort of really,
used to seeing
really personal, but don't sit right in a formal legal document. It does make absolute sense, and then you're not shackled to the legalities of needing to change it in future if you need to. And you can just keep your own notes as you're going along. But I used to say to people, just make sure you're having conversations with people, even now, even when you're fine, even if you think you're never going to need to use these documents. Be having conversations about, sometimes it's difficult things you're talking about, but they will remember those things in future, so that you've at least voiced those things. And as your mind changes over time, keep having those conversations with people. And you just got to sort of try and put your wishes and feelings out there as much as you can while you can, and hope that people remember those in future, I guess.
Do you think this ties in with what the APG was saying about an LPA becoming a bit like a driving license and everybody having one? The more and more we push that, the more we spread the message about LPAs and the benefit of them in the future. If you are to lose capacity, it becomes a talking point, so more people are aware of them, and it doesn't come as a shock when one is being used for a family member. We're just talking about wills, letters of wishes. Everybody knows you should have a will. If you put LPAs on the same pedestal, so everybody is aware of what that concept is, and it won't be so shocking when a family member loses capacity and another family member perhaps is starting to act for them, because we all know what that is.
Exactly.
I mean, the OPG sort of advert, and it was on mainstream TV last year. I haven't seen it recently, but it was out there, wasn't it? That I think it was a mother and a son, and it was she was my voice and now I can be hers. And it's actually a really nice way of putting it. You just need to make sure that the voice that's coming through is from the person that you want it to be. And equally, as you say, Lauren, make sure that they know what your wishes are. It's slightly different, but I still think that there is such a real reluctance amongst people to deal with their wills.
I was just thinking the same thing, actually. People don't like talking about it, do they?
They don't. And I think we've still got a little bit of that around LPAs. I mean, we always sort of say your LPA is almost your insurance policy, and hopefully you'll never need to use it. But, for peace of mind. And I think people, when they eventually do pluck up the courage sometimes to go and talk to somebody about their will and to get their will in order, they sort of take that, it's peace of mind. You've put it in place, and it should be absolutely the same with LPAs, but I do think we still got a bit of work to do there.
There's a bit of stigma breaking down, I think, that needs to be done, really, isn't it? I just think if we all talk about these things more informally, then I think people might start to feel more comfortable discussing it, and then in turn will feel more comfortable actioning these things. It's like when you take out an insurance policy, you don't think, oh God, this obviously means that I am expecting my house to fall down. That's not the case, is it? You sort of hope for the best and plan for the worst, I suppose.
Yeah, definitely. I think our colleagues in our wealth protection team have really been flying that flag for years, and sadly, by the time that clients come to us, generally it's a little bit too late to make the powers of attorney. But what I always find really interesting is the misunderstanding about that, and the amount of calls that we get, inquiries where people say, oh, you know, my relative has gone into hospital and unfortunately they haven't got capacity and I've been told to make a power of attorney. And you know, I guess you could look at that of somebody starting from the point of view that that individual has capacity, and so, you know, support them to consider whether or not they've got capacity to make that power of attorney. But all too often, actually, it's very clear that that individual sadly doesn't have capacity to make the LPA, and it's a deputyship. So I think, you know, yeah, we need to start flying the flag for getting your affairs in order, breaking down the stigma, getting rid of the taboo. You know, I'm not going to lose capacity if I make an LPA. You know, it is there for a rainy day. But equally, I think, therefore, if you are saying I'm going to make this as an insurance policy, it's really important that you keep it under review as well, isn't it? Because if we're talking about wishes and feelings, and in the same way that those change, we might actually want who we've chosen as our attorney to change with that. You know, if we encourage people to make power of attorney as soon as they can, as early on as possible, think about the life changes and choices that we go from. You know, that could in the beginning be a sibling, which, you know, we wouldn't necessarily want our brother or sister then dealing with things when we get married, or, you know, or we divorce, or, you know, we get older and we do want our children. So I think people often still at the moment, because they tend to be made as people are a bit older in life, but I think with LPAs it's important to recognise that while someone's got capacity, they can change them, and they should be reviewed in the same way that you review your will. Okay, you might get it out and go, yeah, that's absolutely fine, I'm happy with that, and I know that this person is the right person to be my attorney and to follow through with my wishes. But if it's not, do something about it, because that's almost worse, isn't it?
Completely agree. And I guess also, you know, the assumption that you don't need to make these things until you're older is perhaps particularly prescient to us, because we see plenty of people that come to us in unusual circumstances that would never have foreseen needing to involve people like us. You know, you know, you're in a car crash and before you know it, your whole life's changed, and you need to consider these things. You just don't know what life's going to throw at you, do you, I suppose?
No, we spend our life planning for retirement, don't we? And making financial plans for ourselves. Like, our legal plans should be exactly the same and just as important.
Yeah.
Do you think that there's still a feeling that people only need LPAs if they've got money, if they've got assets?
I think
still that stigma?
Perhaps that's just a lack of understanding, isn't it?
Oh, it absolutely is. But do you think that that is still one of the, because I know that that's sort of with wills, people say, oh, I don't need a will, I haven't got anything to leave. Do you think people also sort of think, well, I don't need a lasting power of attorney for property and affairs because I haven't got any property or I haven't got any financial affairs?
I do think people think that, actually. But also I think it's going to be really different for the next generations that are coming along, because, you know, even just 20 years ago, people might have had one job for the whole of their life. Their life might be much more predictable than it is for the coming generations. You know, I think they say now people have 6 different jobs, and, you know, that could mean 6 different pension pots with different providers. It could mean you could be doing, I don't know, a side hustle. You know, people make money from the internet. You've got so many different things, and even if it's small pockets of information or money or what, it's still going to be relevant to the future and how that's managed in the future. I had a conversation actually when I was still doing wills and LPAs. Someone said, do I need to write my internet passwords down in my will so that somebody can get into my, you know, access my email accounts and things? And I thought, I actually don't know the answer to that question, because we've not needed to cross the bridge the other end yet with anyone.
I remember that. I remember that happening, and I remember that there were dedicated websites popping up where you could put that information in, and they would keep it safe. They would keep it, and then they would only sort of give that information out on production of your death certificate, so sort of like a data bank, if you like, that you stored your sort of soft data in. So I do remember that happening. Gosh, I'm not that old, am I? God. Well, I think today's been really great, ladies. It's been really useful, not least to, you know, share the whole Britney stuff, and was desperate to talk to somebody who kind of might have something to give back, rather than, you know, somebody who's like, oh yeah, poor Britney, because there's so many issues in there. So it's been really great. I really hope for Brittany actually that she does get some of that autonomy in terms of the decision making back.
I have to say one last thing on the Brittany point. The really scary thing was when they interviewed one of the attorneys and they said, I have never, in my career, I have never seen a conservatorship come to an end.
I was
And I just thought,
absolutely
oh my
astounded.
goodness, because
Yeah.
surely the ultimate aim is, if you
Yeah.
can, to restore P's capacity at some point, and they can
Absolutely.
manage as much of as possible of their own affairs. You want to give them as much freedom and liberty as possible, but in the
What I
US it was
also
like a
found
done
odd
deal.
about that, yeah, and what I also found odd about that was that the lawyer who said it has now recently gone back onto Brittany's
Yes. Yeah.
father's legal team, so sort of gives you an idea. But I could not believe that. I absolutely agree with you, Lauren. Somebody's incapacity is the start of a journey for many people, and sadly some people won't be able to regain capacity. But yeah, you're absolutely right, and that's always our point, our starting point, isn't it? This is a journey that we come on with you, and for whatever reason you've lost capacity, but we're going to do what we can to work with you to get you back to that state of autonomy.
It's always the best day, isn't it, when you can restore an individual's capacity? It's the best phone call that I've ever made to a client. I've had the order, you're restored, you don't need me anymore. You know, you've built the relationship with the client to be able to help them in different ways once they are restored. But the joy is fantastic. To like you've been restored. You don't need the court's interference anymore, and that is the best day. And it's what
Must be a very freeing feeling, mustn't it?
Yeah.
And actually what you know often happens in those situations is that the client has really valued that professional input over the years, and they've identified the professionals that they do need to work with, you know, and that might be their accountant or their financial advisor, and it might even be ourselves in the form of a professional trustee, to just kind of be that that sense check or that safety net, or knowing that we're there. So yeah, I was absolutely astounded when she said that. I could not believe it. And she seemed like she'd been practicing for a few years as well. She wasn't straight out of law school, as they would say in America. So I was, gosh, what a difference
now.
I found that very, very alarming. Very alarming.
So what have we learned today, guys? We've learned that I'm going to go get my power of attorney out of the drawer and just make sure it says that the attorney that it says I'm happy with. Yeah, that's what I've learned today. Yeah, but I think we are really focused on P, and I think we always, you're right, we always put them at the centre of what we do, and actually sometimes that isn't always possible, but it's always where we start.
And we'll always try, won't we? It's not, you know, you don't just throw in the towel if you can't, if P can't answer a question.
And for those cases that come to us where we have no idea who that individual is, you know, we do what we can, and we try to, it's a bit like a puzzle, isn't it? You know, it's a bit like finding the pieces to the puzzle, you know, whether that's going out to where they've lived, and you know, it's really personal actually, going through what is essentially someone's life, but we don't do it for no reason. We do it because we want to understand what that person would have wanted.
Exactly. And it feels like a real privilege at that point, in a way, without sounding too soppy about my job. It's quite special in a strange way to work through somebody's entire life and try and understand them.
Can also be really fascinating. I remember years ago I had come across a gentleman and walked into his room, and it was this really unassuming house, but when I walked into this one room, there were share brochures from his shareholdings and an AGM invite stacked from floor to ceiling in this massive room. And I knew instantly I was going to be a busy girl that day. But this gentleman had literally taken pleasure in basically playing the stock market. And he'd grown up in that house, lived in that house, and it was like walking back in time to the 1940s. And he was worth multi-million pounds just by playing the stock market. And it was fascinating because when I went to see him in the care home, I took a couple of the share packs with me and the brochures with me, and we basically had this fantastic conversation because I knew that that's what he liked, knew that that's what he would enjoy. And I took him a copy of the Financial Times, and he sat there and he told me all about what he'd done, but nobody in the care home knew that before I went there. So yeah, you really can make a difference.
We just have the best job, don't we? Getting to know these people, and no two people are the same.
Flipping challenging sometimes.
Take the rough with the smooth.
Yeah.
But yeah, we do. That's just come back to me actually talking about this. It's interesting. I haven't thought about that man for years, but yeah, it was.
But it's stuff like that can then open up somebody to other people. Like if if a carer comes in later on in the day, they see the Financial Times. P has been buoyed up by that conversation with you, and before you know it, they're chatting away to everyone. They've made new friends. They've remembered things they hadn't thought about for years. It can be really special.
Yeah, and actually from that day on, all that he really enjoyed, he'd been getting the local kind of paper that was sent in, and that didn't stimulate him in any way. And then we got him the Financial Times going in every morning, and he just he was absolutely brought light to his day. Yeah, it was brilliant. So yeah, we'll always do what we can, but it can be a challenge building that puzzle. It's cool.
That's right. Awesome for coffee kitchen chat.
Absolutely. This is exactly what we've missed, isn't it, during the pandemic, being able to just chat through our recent cases, what's going on.
And we'll try and do it again, I think. And I think if anybody has any suggestions of things that we can watch, there's loads on at the moment. So if anyone's got any suggestions of anything, drop us an email, or comment or wherever this is going to go out, and yeah, we'll get on it.
Absolutely. Guys. Yeah, thank you.
All right. Bye.